Alrighty, let's do it. What's going on, everyone? My name is Rafael Jermison. I'm with Stamper Signings. We're a nationwide notary service that specializes in notarizing estate planning documents. We are a notary service that's based out of California. And today we're back with another video in our document review series where we'll be going over California documents. I previously had this I previously had this video uploaded, but a couple of folks in the comments let me know that there wasn't any sound. So we're going to go through this again. So let's get right to it. So in your estate plan signings as a notary in California, a common document that you will come across is the grant deed to revocable trust. And the grant deed to a revocable trust, this document means it's a transfer of ownership. So for example, let's say I have a property that I purchased. My name is Rafael Jermison. I purchased this property, but because I'm setting up my trust, I'm going to transfer the property into my trust. How am I able to accomplish this? With this particular document, the grant deed to a revocable trust. So I'm Rafael Jermison. I'm the grantor, and I'm hereby granting to Rafael Jermison, trustee of the Rafael Jermison Living Trust, dated December 1st, 2024. When we're working with notaries and they haven't done this signing before, a question that we always get is they want to confirm that if the signer can grant the property to themselves. It's a question that we always get. Technically, they're not granting the property to themselves, they're granting the property to their trust. But because they're the trustee of that trust, it appears as if the signer is granting the property to themselves. So to recap, this document is a transfer of ownership. The signer is granting the property to themselves as trustee of the trust. So they're transferring the property from their personal name into their trust. So that's what this document is. You then will proceed with getting this document notarized. Commonly with deeds, what you want to be on the lookout for is how the signer name appears. You will see that the signer may have let's say we have John Mary Doe, right? The Mary is the middle name. They may have purchased the property as John Doe, but they're granting the property as to their trust as John Mary Doe. So you may see that as it appears. You always want to have the signer sign their name as it appears, because when they submit this document to the recorder's office, and if the document isn't, and if they didn't sign their name as it appears, there's a good chance that the recorder's office will reject this document. And the next step, you want to notarize this document. So as a notary, you want to print, sign, and you're going to stamp. Now, here's two things that I want to point out. As of late, we've been coming across estate planning attorneys who are sending us these updated acknowledgement forms. As you see here, the acknowledgement forms in California normally say notary public, but this says a notary public. Don't worry, this form is compliant. As long as you have this box and the appropriate notarial wording is listed, this document is in compliance with the notary laws in California. So don't be alarmed if you see a notary public. Leave this as is. Secondly, we've had notaries previously who print their name here, but their name that they printed doesn't match their stamp. So if you do not print the name the way it is, presented on your stamp, and your clients submit these documents to the recorder's office will reject this document, because the notary's name that's printed on this document does not match their stamp. So always be sure for all your documents that you're notarizing, the name that you're printing in the notarial section matches the name on your stamp. And this is how you would officially notarize this document. So when your clients go to submit their deed documents to the recorder's office, they're also going to submit this document as well. PCOR, which is short for preliminary change of ownership report. And this document, this document tells the county what's going on with title of this property. For you notary signing agents, you should be accustomed to seeing this form. Normally, you as a notary would need to have this filled out, but when you're working with estate planning attorneys, they're already going to have this form pre-populated for you. So only thing for you as a notary, what you want to make sure is that you get the signature. You want to get their signature on this document. Again, it's been pre-populated, so it's going to be dated. You're going to have the telephone number, email address, the title, what's their title as trustee. You're going to have their name printed, and then you want to make sure you collect that signature as well. Now, depending on what county you're going to submit these documents, or your clients are going to submit these documents to, especially for you notaries out there that's providing document recording services, where you're taking your clients' documents to the recorder's office for them. If you're performing that service, always make sure that you call the recorder's office in advance before arriving, because certain counties are very particular about these documents. And sometimes the grand deed and the PCOR is not enough. They may want a copy of the certification of trust, and they may also want a copy of the full living trust. So always make sure that you call in advance, so that way you're not wasting your time and you're not wasting your client's time as well, because the recorder's office can be very particular. So always call in advance. So next we have the uniform statutory form power of attorney. Also could be, you'll also see as the general durable power of attorney in your signings. And with this particular document, the power of attorney is just a legal document that's going to let you pick someone you trust to make important decisions about things like money or property for you, especially if you can't do it for yourself. So it's going to show a list of powers that the principal can grant to their agent. If they have specific powers that they want to give to the agent, they would initial which powers that they want to grant. But if they want to grant their agent all of the powers listed above, they will only need to initial here in this section where it says N. Commonly, we'll see notaries have the signer initial every single one, but you only need to have them initial N if they want to give the powers, list all the powers listed above. And then this document does need to be notarized. Make sure you collect a signature. Make sure you print, or also where it says here, insert name and title of officer. Always print your name, print notary public, provide a signature, and stamp it. Again, make sure you sign your name as it appears on your stamp. Next, we have the HIPAA authorization. This is a document that lets you choose who can see your private medical information, so they can help with your care or decisions. Normally, the signers are going to have this document in advance, or have a final draft of this document in advance, and it's going to have their date of birth. So always confirm if their date of birth is correct. If so, we're going to move on to the next section for you as a notary, where you have to notarize it. So let's recap. You're going to sign your name as it appears on your stamp, print notary public, provide your signature, and you're going to stamp this document. Next, we have the Advanced Healthcare Directive, also known as the Healthcare Directive, and also known as the Healthcare Power of Attorney, depending on what state that you're in. And this is just a legal document where you choose someone you trust to make medical decisions for you if you're too sick or unable to decide for yourself. This document is normally about 5 pages, typically more. It's going to have the signer's physician information on there. It's going to have, if they want to have the choice to either prolong their life, or if they want their agent to pull the plug, so to speak. Make sure you get their signature, make sure their name is printed, make sure you collect their mailing address, make sure it's dated. You want to sign, you want to print your name, provide a signature, and then you're going to stamp this document, and that's how you would complete this. Next, we have the certification of trust. The certification of trust is just a document that proves that the trust exists and shows important details about the trust. You will see trustee verbiage on these documents, whether it's trustee, grantor, grantee, assigner, principal. Normally, for the attorneys that we work with, they normally don't require the signers to provide trustee verbiage, but you always want to follow up with the attorney's office just in case. Just in case. It's always to be better safe than sorry, but 9 times out of 10, they're going to say no. You're going to get their signature, print your name, print notary public, provide a signature, and you will stamp it. Next, we have the living trust, and the living trust, excuse me, a living trust is pretty much a legal plan where someone is going to put their assets and their belongings to make sure everything is taken care of and given to the right people after they pass away without needing court approval. To make it simple, having a living trust in place helps the estate and helps their estate avoid probate. And you're going to see the trustee verbiage for grantor or trustees not required unless otherwise told so. You're going to provide a signature, print your name, print notary public, signature, and then you're going to stamp this document. Next, we have the will. And the will is a legal document where you're going to write down who should get your assets, money, belongings, and other things after you pass away, and who will make sure it happens. And the person who's going to make sure that happens is the executor. So you want to make sure that you collect the signer's signature. And then for you as the notary, you can serve as a second witness. Want to point that out. Because this document doesn't need to be notarized, California notaries are allowed to serve as a witness. And for both witnesses, you must provide a signature, printed name, and address. This is a common mistake that we come across where notaries will only collect just a signature, but they don't collect the printed name and they don't collect the address. Let me paint a picture for you. Imagine if you were setting up your estate plan and you have siblings, and imagine if you had children, you had siblings, or whoever is a family member who stands as a beneficiary or trustee. Let's say you get this document signed, and the witness only gets has an illegible signature where it looks like it's just scribble, but they didn't print their name and they didn't provide the address for both witnesses. What would happen if one of the siblings or one of the family members falls out? Whoever's in the trust, they all fall out with each other, and then the estate is their estate plan is contested and it's taken to court. What if the person that takes the estate to court wins and the court rules in their favor? And they rule in their favor based on the fact that they weren't able to get in contact with the witnesses because they don't know whose signature it is because it's an illegible signature. They don't have a printed name and they don't have a mailing address, no way to get in contact with them. You want to ensure that this document is filled out correctly because you want your clients to avoid probate or any situation to where their estate is being contested. You just want to avoid that issues down the line. So always make sure you get a signature, printed name, and address for both witnesses. And that's a reminder, California notaries can serve as a witness for estate plan signings. If someone tells you otherwise, it's cap. We have the funding acknowledgement. The funding acknowledgement is a document where you confirm that you've moved your money, your property into your trust to make sure it's protected and managed according to the signer's wishes. So this document, again, the signer has been advised and they're aware that they need to move those things into their trust. It doesn't need to be notarized. Make sure you collect a signature. Next, we have the assignment of personal property, also known as the assignment to the property of trust. It's a document where you move your personal belongings, tangible personal property like furniture, jewelry, etc., into the trust. So they're included in your estate plan for managing and how it will be distributed to the beneficiaries or trustees. You see, we'll have the signer verbiage, not required unless otherwise told so. Get the signer signature, and then you're going to notarize this document. So I included this another document, which is the general durable power of attorney, which could also be the uniform statutory form power of attorney, depending on which attorney that you're working with. So for the statutory form power of attorney, it doesn't require the attorney in fact signature to be notarized. However, for the general durable power of attorney, you may come across an instance where the attorney in fact needs to be present for the signing, and it's going to ask for their signature, it's going to ask for their driver license number, and it's going to ask for it to be dated as well. So if you're working with an attorney and they're asking for you to print out the documents and they send you the documents in advance, if you see this document or if you see that additional people that's listed on the documents are needed to be, that's listed and their signatures are required to be present, always follow up with the signers in advance so that way they're not surprised when you get to the signing table. You want to make sure, again, that you're not wasting your time and you're not wasting your client's time and the attorney's office time as well. Always make sure that the necessary parties that's listed on the documents are present so that their signatures can be witnessed in front of you, especially for the ones that need to be notarized. So for the attorney, in fact, again, we need to get their signature, driver license number, and a date. You'll often see for these power of attorneys where, especially if you're working with married couples, the married couples, the husband and wife, they'll serve as the attorney, in fact, for each other. So in that instance, if they're serving as their agents for each other, you already know they're going to be present for the signing. You don't need to contact them to make sure that they're available outside of just confirming that they're going to be present for the signing. And then the attorney in fact signature does need to be notarized. We're going to print California, county. We're going to put the date. You're going to print your name, personally appeared, the attorney in fact, print their name, make sure you get your signature, and you're going to stamp this document as well. So, ladies and gentlemen, that is how you notarize an estate plan for California. If you're a notary who wants to work with us and you want to add estate plan notary services to your business, we currently assign out orders via Closewise. So if you're not on Closewise, I definitely encourage you to sign up on the platform. So that way, if we have any signings that's in your area, we can reach out to you to request your availability. I hope you guys got a lot of value from this video. I hope you take this information and apply it into your business, so that way you can start booking your own book of business as well, and you're aware of how to notarize these type of documents. Make sure you like this video. Make sure you subscribe to our channel for more notary educational content. And we appreciate you guys. Love you all. Peace.